Our presentation is on estate management, and we have Miss Latoya Williams from the Administrator General's Department. She is going to tell us all about estate management, which has to do with wills and a lot more. So, without any further delay, Miss Latoya Williams.
Good afternoon, everyone. Mrs. Sadler Graham. Sadler Graham. I did. I did. While we were. Okay. So, good afternoon, everyone. I'm Latoya Williams. I am a trust officer at the Administrator General's Department. I've been with the department for the past 23 years. I started out in accounting, but as I often say, the Lord would have it that I would have transitioned to estate administration, which includes, as the words say, administering estates. And I've since ventured into law, changing my career path from accounting to law. Still have a love for accounts, but for now it's just about the law and learning more as I go along. So as it was stated, my presentation, as you can see on the screen, is about estate planning. Mr. Welch, right? I can't forget that. My manager's last name is Welch, so I won't forget. Right, thank you. So, what is an estate? Without looking on the screen, please, without looking on the screen, can anyone tell me what is an estate? Don't, you cheat, you glimpse up there, you look already. Okay. If I was marking you on a paper, you'd have probably lose half mark because you put the life in there. But your estate is what you own, especially in death. So you take out the life. So when you're alive, it's your net worth. Once you have passed, it now becomes your estate. So your estate is everything that you own so it's your assets minus your liability. Right. Many persons tend to forget about the liability part, but what you owe is to be considered in debt. So it's what you own minus what you owe. So your assets minus your liability. Next slide. So estate planning. We have established what is an estate. Now we have to plan our estate. Planning our estate entails the management, how you would want your asset to be distributed after you should die. So here we have, it's the process of planning and arranging for the disposal and management of your assets acquired during your lifetime upon death. So that is estate planning. A brief intermission while Mr. Welch get back to his position. Thank you, sir. So there are a few things that you should consider. Next slide. These are what you own, what you owe, who will take care of your affairs, as in who are your executors, who your executors will be, who do you want to get what you own, as in who will be your beneficiaries, who will look after the affairs of your children's emotional and personal well-being, and who will protect your children's assets. So you can plan to say who you would prefer to be the guardian of your child once you should pass. And if you already have an estate plan in mind, you must take into consideration if it needs to be updated. Meaning you made it like early 20s, but you have acquired further assets, and you can consider updating that estate plan that you would have already have. Next slide. So here we have a few types of estate planning. So the will is just one type of estate plan. It's not a must. There are other options you can consider. You have the joint tenancy where you own, or joint ownership where you will own the assets with someone. This simply means if myself and Mrs. Graham bought a piece of property or a motor vehicle, jointly it means both of us has 100% share in that asset. So when if I should pass, the asset now belongs 100% now of that asset now belongs to Mrs. Graham, as the right of survivorship under law will chip in and the asset now belongs to her. We have inter-vivus transfers. These are transfers done during your lifetime. Persons tend to explore these options because it is less costly as to having a will and getting the will probated and going through the courts and all of that. Where and it evade your estate from paying what is a tax that is known as estate duties. It's a tax payable upon death once property is involved in your estate. So if you have a property, you can transfer your property during your lifetime to whomever you want to have the property when you should pass. So there is also naming of beneficiaries on life insurance and credit unions, because credit unions do allow for you to have a nomination form where you can name your beneficiaries. Once you have explored those other options, as in joint ownership, inter-vivus transfer, naming beneficiaries and trustees, you do not need to make a will. So a will, as I said before, is one type of estate planning. So if you own if all you have is a property, a motor vehicle, and a bank account, and someone else's name is on that asset jointly, you can't will it. You can't put it in a will. Even if you write it in a will, the will is not valid, because you cannot will a joint asset. If you explore the inter-vivus transfer, it would mean that you would have transferred the asset during your lifetime. Therefore, there's no asset for you to put on a will. If you explore naming beneficiaries on your insurance policies, your credit union, for some of us where we might work with government or even private, and you have pension plan, you are able to name a beneficiary. You cannot will any asset that you have already named a beneficiary during your lifetime. And if you have a named trustee, where a trustee is one that would take the place of a child. So if one of your beneficiaries on your investment asset is a child, meaning someone under 18, you are required to name a trustee, which is someone over the 18 years and older. As the law would have it, once you're 18, you are not an adult. So the trustee must be 18 years and older. So if you have a beneficiary who is a minor under the age of 18, and you leave a trustee for that, for the asset for the beneficiary, you do not will that asset. If you name the beneficiary, the minor, but you don't leave a trustee, the institution that you have the investment with or the insurance with, based on their policy and what they have written, it might say they will hold the funds until the child reaches 18, or they may choose to get the administrator general department involved where there is no trustee. But we'll get further into that. You can also cover your funeral expenses. Some persons, all they don't have any tangible assets. All they have is some funds, and they decide, say, hey, I don't want nobody to give me no pion funeral, so I will pay for what I want. And they go ahead and they cover. They pay the funeral home, they buy the plot, they do all of that, and they yes, it is done, and it is a practice in Jamaica as well. It's not foreign. It depends on the agreement between yourself and the funeral home, because many times, well, In recent times, my family buried my aunt and my grandmother. And when we went and saw plots and we were like, why we can't get this? They said, no, those are already paid for. Even now, if I go to my mother's grave, I would see empty spots and they would say it had been paid for. And my mother died 31 years ago. Right. So once you have covered that, you would not need to make a will. Once you have explored any of the other options from 2 to 6, you will not need to make a will. Next slide, please. So, but today I'm here specifically speaking to you about making a will. If you look on this piece of white paper is our will form. On the front is just instructions. The instructions are, the authority for the instruction is the Wills Act of Jamaica, and they probably would have ventured into the Interstate Estate and Property Charges Act. But it's mainly the Wills Act of Jamaica and what is required to make a will valid. So can anyone here tell me what is a will without reading my slide? Yeah, man, somebody. It's a? Okay. Your face looks familiar. Have you heard me present it before? Oh, I know you. Hi, my dear sister. So, a will, as she rightfully said, it's a legal document that sets forth the wishes of the testator. Who is the testator? The person that is writing the will. So, you're writing your will, you're known as the testator. Your will, if you can read it, I think the light is making reading a challenge. But, as I said, it's a legal document setting forth the wishes of the testator. Next slide. Right. So the will must be in writing. It can be handwritten, typewritten, or computer printed, or in braille. So even the law allows for a visually impaired person to prepare their will as well. And it is valid once it has the 3 main clauses to be valid. So I will take you now on the second page, the clauses in a will. So at the top, you'll see this is my last will and testament. You skipped. Go back, please. Right. So at the top of the will, you will have the introductory clause. So the introductory clause is just capturing the name of the testator and the address of the testator. Below that, so there you have it. Below that now, you will have the revocation clause. It's a latter will revokes the earlier. Meaning, if you write a will last week and you write one this week, the one this week revokes the one last week. So you have the revocation clause that says, I hereby revoke all testamentary disposition previously made by me, and declare this will to be my last and final, my last will and testament, right? So that's the revocation clause. It comes right after the introductory clause. Next slide. After the revocation clause, you would have the clause that appoints your executors. So who are executors? They are persons who will take care of your affairs once you pass. So once you close your eye, and the doctors call it, you have transitioned. Your executor immediately can take charge of your estate with the will being left. So the executor now will have the will probated, get the services of an attorney, have the will probated, obtain what is known as a grant of probate. The will itself cannot be used. It has to go through the court. The court has to look on the will, approve that the content and the will itself is valid, and then they will issue what is called a grant of probate, naming the executor as the legal representative. Yes, you can. So your executors can be a beneficiary under your will. So, but the executor is allowed to charge a 6% commission to execute your wishes under your will, and this is by law. So even leaving a gift under your will for your executor, they can still opt to charge your estate the 6% and collect their gift. The option to forego their commission is left to them based on the act. 6% of the value of your estate. So if your estate value $10 million, it's 6%. If your estate value $700 million, it's 6% of that. Beneficiary. Yes, your executor is anyone over the age of 18. So I always say, if you are husband, wife, children, and you're leaving all your assets to your spouse and your child or children, they can be the executor and they can be the beneficiary. That's the only way you basically eradicate the 6% being charged, because everything is left to them. But at the same time, if you leave your husband to be the executor and your beneficiaries are your children and your husband, he can choose to take that 6% commission as well as collect the gift. If you're, as I said before, if you're jointly held, you cannot leave that asset under your will. So if the property you own is jointly held, as in Latoya Williams and Sister Sadler Graham hold this property jointly, I cannot will it, she cannot will it. The only time it can be willed is if one of us pass and that the death of that person is noted on the title. The property is now solely belongs to Sister Sadler Graham, and she can now put that property in her will because she's the only owner of the property. As in, if the property is not jointly held and you're leaving it to someone, if you can say what the person does with the property, yes, you can. You can say, I leave the property to my husband, Victor Brown, as long as he does, and he's to live there as long as he does not remarry, or he is to live there until death. If you leave it like that, the property, once Victor dies, the property will revert to your estate. And then it will be administered according to law. But you can say, I leave the property to my husband, Victor Brown, to live there for the rest of his life. And upon his death, the property should be passed to my grandchildren, so and so, whether as joint tenants or in tenants in common or whatever it is. No, it's it's your will, so it's whomever you choose to leave it to. So you can leave it to a church sister. You can, okay, when my husband say the property is next door to the church, and when your husband pass, the property should be transferred to the church. You can.
So for the benefit of the stream, please speak into the mic when you're asking the questions.
Okay, I am asking, if you are married, out of the two of us, one person can go and make the will without the next partner?
Being married, all right, the will is an individual thing, right? The will is individual. You don't make your will together. Then normally you have your will and your husband has his. So you can go and make your will and your husband can go and make his. Because if you have all your assets jointly held, you don't need a will. But if it's individually owned, you can only will what is owned by you, and your husband can will what is owned by him. But if you want to make your will with your husband being present, that's your decision. That's your choice. Mike.
Okay, we have a house together, and I would love to make a will. We don't have any children together, but I have a child. He have children.
I'm going to stop you. First question: how is the house owned? Is it joint tenants? If it's joint tenants, you can't will it. But if it is tenants in common, where you have 50% share and he has 50% share, then you can will just your 50% share. So what I'll say to you, when you go home, look on the title to see if it is joint tenants or it is tenants in common in equal shares, or it specifies how much share each person. It can be 50, it can be equal, which is 50-50, or it can be you own 25, him own 75, it can be you own 60, him own 40. It depends on the agreement at the time of purchase. So if when you look on the title, it says you both hold the property as joint tenants, you can't will it.
So in other words, what do I do?
You can't do anything to the property. The only thing that can be done is to sever the joint tenancy. And that requires it can only be severed if both of you agree to do it and both of you going to sign up that he's taking off, he's removing his name and giving you sole ownership of the property. Right, and it might include a lot of fees.
So it would have to just stay like this, and if I pass, he gets it, and if he pass, I got it.
Yes.
Okay, thank you.
All right. I hear you say that you can't will a property held in joint tenants. But I have a question. Is it prudent because as you said, it's a matter for the court to determine, right? When you make your will, you're making your will, you don't know who's gonna die first. But if you include that property, knowing that it's jointly held, but if you make your will and you include it, because
your will is void.
It's not. No. Is it void?
You can't include a joint asset
No.
in your will.
Wait. The will cannot be void because that's not the only item on the asset. So wait, let me finish because I want to make a point to make it clear. Because you say you're making a will. And you make your will to preempt death, right? So is it that so it does the court, because that item is on it, void the entire will, or just that entire that item becomes void upon the administering of the estate?
I would have probably preempted my answer, but that asset, the asset we are talking about, the law states that once that asset is jointly held, it cannot be willed.
Yes, I get
so if that asset is in your will, it will not be administered as to how you would want it to administer because it is jointly held. But it will, the remainder of your will be administered in accordance to your will.
I got that. So my second question would be, and it goes back to my first point, because when we make our will, we don't know who will die first. So is it prudent? Do you think it is prudent to make a will? Because we make, especially as spouses, you make your individual will. So if I include that asset in my will on it, and when suppose after it doesn't come alive until I die, and when between that time that I die, the spouse dies, right? You understand what I'm saying?
Wait, so you're saying you make the will,
You,
you included the joint asset,
yes,
but your spouse end up dying
dying.
before you.
Because remember, the will is not for me. I am telling, no, I'm telling the court or telling whoever, the testator, who I want to get it. So if it becomes, I have the right of survivorship after the spouse dies, and it is included on my will. The spouse has died, and it naturally becomes my, and I had it on my will before. So I am telling the court who I want to get it. No, outside of the partnership, seeing that I become the right of survivorship.
Hold on. Let me put some context to what you're
Yes.
saying. You have your will, married, you own the property jointly.
Yes,
You put the property, joint property, in your will.
yes,
Your spouse end up dying before you.
yes,
And so you're saying the property is already in my will because I would have had it, right? The property don't become solely yours to will until after the death. So your will date would have been January 2025. Your spouse passed July 2025. The asset is not yours to will in January, so it still would not be administered. It would have to be treated because your spouse death has to be noted on the title, and the dates must be in alignment, in order for that asset. So your will dates, it would show that you would have willed a joint asset. And as I said, the law states you cannot will a joint asset.
So you're saying then that I have to prepare a codicil or something after to amend it?
You can prepare a codicil, or you can you can revoke that will and rewrite another. But the dates,
So it is important.
right, it is.
Very well.
Take, for instance, the principal who died from Jesse with his wife, right? I am thinking along that part that if it is just in case, because both of them would have passed at the same time, if either of them would have prepared a will before that, it would have any power.
Okay. So in a situation like that, for the reasonable man, which the law sees us as a reasonable man, just the natural man, we would say both of them die at the same time. But the law has things in place to say who died first, or to assume who dies first. So if they can't separate the time of death to say who died first, the law implies, let me not use the word assume, the law implies that the youngest of the two died last. So if the husband is 28 and the wife is 29, and they both, when they arrive on the scene, the doctors and everything to confirm death, if they cannot separate the time to say based on, I'm not a medical doctor, so based on whatever they look for, if they can't determine that, okay, the man died first, it will be implied and entered that because he's 28 and she's 29, he died last. So in administering in the joint property, he would have the right of survivorship and the property would fall to his estate. In the event that that is contested, it will go before the court and the court will have the final say. Where am I? So the when they see how far when they carry me, I'm talking about executor, they carry me all the way down the road. So the executors, as I say, can be anyone over the age of 18. What we encourage is that you have a conversation with whomever you're leaving to be your executor to say, hey, I'm making my will. I would like for you to be the executor. Give that person the opportunity to say yes or no. And we also encourage two persons, you have two executors. Why? In the event that one person, you didn't have the conversation and one person decide that they are not going to do anything, the other executor can step up and have your will probated and act accordingly. If you don't have a conversation and say both persons can choose not to, because persons don't want anything to do with deadlift. You do have persons that don't want anything to do with deadlift, because all if you leave a will, all if you name one beneficiary, all if you name a trustee for the minor, the trustee take the money and gone, and you never see the person again. But at the end of the day, the law requires these steps be made, and if you don't have estate plan in place, the law will dictate how your estate is distributed. We'll speak further to that. Next slide. So after you hear it just states who is an executor, and I'll just read. An executor is a person who distributes the property of the deceased person according to his wishes as mentioned in the will. Next slide. You're free to name your spouse or adult child or a trusted friend or relative as an executor. It is also best to inform the person beforehand. Next slide. The role of the executor, we went through it, but just for the purposes of the slide, they secure the will, have the will probated through the courts, collect the assets and settle all debts of the estate, and then they move to distribute the gifts based on the will. I pause there. Your liabilities must be settled under administering your estate, whether you leave a will or you don't leave a will, whether you die testate or you die intestate. When you have a will, you are said you have died testate. So if you die testate, your executor must investigate your assets. Once they are confirmed, collect your assets, clear your liabilities, and then dispose of the remainder of the estate. Dispose the remainder of the estate. So in the event that someone pass leaving just realty meaning house, land, businesses, personality. In estates, and you have personality and you have realty. Realty is mainly property, land, empty land, or land improved with buildings on it. Motor vehicle and like shares, they are considered, although not liquid, they are considered personality because they are easily liquidated. So if you die leaving just shares, motor vehicle, property, no cash, and you have debt, you have loan at the bank, your executor will have to liquidate one of the assets in order to clear your liabilities and then move to distribute the remainder of your estate. Next slide. Before we get to discuss, on the paper you have a blank space. That's where you would list your assets and name who gets what under your will. We ask that you be as specific as possible. So if you have a property and it's registered, because properties can be registered or unregistered. Once your property is registered, it falls under the Registrar of Titles Act, called the RTA. It therefore means you have a title, a duplicate certificate of title. It is seen to you as the original, but it's not the original. It's a copy that seems as the original. I hope I'm making sense to you. That title has a parent title that is held by the National Land Agency. So although it is thick and it is on that thick piece of paper that feels like cartridge paper, it's the original to us, but it's called duplicates. Right. She's correct. Property is not owned by us. Property, the entire land is owned by the crown. It's owned by the government. The closest a person comes to owning a land, is on your title, you would see Latoya Williams own the property, probably not in those exact words, but has a fee simple interest in property in the estate of, in the property located at, in the parcel of land located at. So the closest you get to it is owning a fee simple interest in the land. That's the closest, surest form of ownership. We don't really own land.
The Maroons don't own their property.
That's a different conversation that I honestly don't want to venture into that, because it is in writing that they are a sovereign group, so I would not want to venture into someone's sovereignty. We are not going there. So, as I was saying, the registered land would have what is called a duplicate certificate of title. That duplicate certificate is identified by a volume number and a folio number. It's normally at the top. Sometimes it's at the top right or the top left, but it's always at the top in bold numbers at the top. So when you're making your will, say you own more than one property, we ask to be as specific. So once you put the volume and the folio number, we'll know exactly which property you're talking about. If you have a motor vehicle, we ask that you put the chassis number on your title, because you might change the color. You might change the color of your vehicle, you might change the engine, you might change the license plate, but the chassis number remains the same to the vehicle. So it's easily identified. So be as specific as possible when you're listing your assets and who you want to get them. Now that takes us to the residuary clause. The bookstore I know sells will forms. Back in the day, they didn't include a residuary clause. So what we would see happening is persons would have made their will and they would have acquired other assets after making the will, but they didn't update the will. The will is still valid, just that what is left on the will at the time of making the will, what was owned by the deceased, will be distributed according to the will. But the other assets owned after making the will now be distributed according to law. So the person, although there's a will, and I said the person would have died testate, where there's asset not included on the will, the person would have died partial intestate. So testate, as I said earlier, she asked what's the difference between testate and intestate. Testate, as I said earlier, is where you would have made your will. Because in writing your will, you are the testator. It's your last will and testament, and you have, once you make the will and sign it and it's valid, you would have died testate. If there's no will made, you would have died intestate.
Thank you.
You're welcome. Or the will declared invalid. You would have died intestate. But if you pass and the will is valid, but it doesn't captures all the assets or deals with all your assets that you would have owned during your lifetime, you would have died partial intestate. Meaning, the house, the car, the bank account that you leave on the will is going to go to whomever you left it to. But the other house and the other vehicle that you would have acquired after you made the will, and not you, that car and house will be administered according to law, according to what the government set out in the Intestate, Estate and Property Charges Act. So this clause can remedy that situation. So all the clause says is all the rest and residue of my estate I give to. So upon writing my will, I only own a house and a car, but I don't know when that going come, so I will it. I'm leave it to my husband and my kids. But God would have it that I turned to the wall and I cried, and he added more years to my life. And he equipped me to own another piece of land. Me now buy shares in a Transjam. I have shares in NCB, but me forget say me must go update my will. That clause captures all of that I would not have listed at the top. So it could be a case where the person name that is there end up getting more than the person up the top that get the house and the car. That clause also captures gratuitous payment. If you're working with government or any private entities that pays gratuity upon being vested after a certain amount of years, you may not know how much you're entitled to. So that clause would capture it. Your NHT refund is paid 7 years in the back. So the last payment you get was for 7 years, your deduction 7 years ago. So the other 7 years, that clause captures it. And as it is now, you can't name a beneficiary to collect your NHT refund. That clause captures it. If you're on the job and God forbid you fall and die, the job, and it is the middle of the month, you are entitled to be paid up to the date that you are on the job. That clause captures your unpaid salary. If you are someone that don't take vacation leave because you don't like staying home, you like to be active, if you're a workaholic, they call it, your vacation leave and you fall and die, that clause captures your vacation leave. Because if you were retiring from the job in the middle, if you are resigning from the job in the middle of the month, they would have to pay you. They would have to pay you for your vacation leave. But this now is a permanent, well, right, you're leaving. Not just the job, but you have gone. You are entitled. So a lot of persons don't know about these payments, little payments. So your estate tend to forego it unless your administrator is equipped with that knowledge or is being guided by an attorney. They would make them aware of this. So that clause would capture all those assets that you failed to deal with in the body of your will. Next slide. So this now brings us to the foot of the will. So at the foot of the will, you sign and you date. In the presence of, anybody can tell me? No? How many witnesses? You must sign and date in the presence of 2 witnesses. 2 witnesses must be present at the same time. My lovely sister here and Mrs. Sadler Graham, and I'm making my will. I can write it, but I must sign it in front of them, and then I turn the paper to them, and they sign. She signed in front of us, and then Mrs. Graham signed in front of us. If that's not done, your will is not valid. It clearly states it in the Wills Act. As I said, the instruction on the front is taken directly from the Wills Act. So if you don't trust what I'm saying or don't agree with what I'm saying, you can always go ahead and read the Wills Act on your convenience. But you must have 2 witnesses and the testator signing and dating at the same time. You don't need a justice of the peace, and you don't need an attorney or a notary public to sign, date, and stamp your will. If the person signing is an attorney or a justice, they are signing in their regular capacity as a normal citizen and don't need to affix their seal or their stamp to the will.
Question. When signing, should the signatures be on the same page?
Of the will?
Of the will.
It must be. If your will span 2 pages, sign every page. You and your witness sign every page. If it pass 1 page, sign every page. question around that.
Good afternoon, everybody. If a
Afternoon.
will is made and your name is on it, but you did not sign at the time, you wasn't in present, can that work?
So who signed it? Who signed it?
I'm not sure.
You're not sure? The will was made. So
It was done donkey years ago. I didn't remember nothing about it. And it happened.
Is it your will?
No.
Someone that you know,
Yes.
they signed the will, they made the
I
will.
don't remember how it was done. I know I have the will. They eventually give it to me to sign some documents, but the other person stopped me, say I should not sign it. The other person lives abroad. She said she's the she's the head executor. So I have to wait on her. And that I've been dragging out.
No, hold on. You see, in law, when we are presented with certain situations, we have to ask a certain type of question in order to get certain clarity. So this seems to be a personal one. So I don't know if I should go ahead and ask you the question here, or you would want to speak to me afterwards. But since you have piqued my audience interest, right? And if they might be thinking now, what is she really saying? I'm going to ask you a few questions curtailed to privacy. So someone wrote a will.
Yes.
But the will was not signed by the person who wrote it. Is that what you're saying?
Yes, it was signed by the person who wrote it.
Okay. See, clarity is good.
But I can't remember being there in present. Because that
Okay.
happened years
So
ago.
hold on. So are you a witness to that will?
It has written with my name as executor.
Sure. I was wondering if you're indulging in. But the will was written, it was signed. You are left as one of the executor. There's another executor who is overseas, right? So the person now passed, and you are acting in your capacity as executor. But you're saying you can't recall being there. The executor don't need to be there upon writing the will. Right. So you see, just as I said earlier, she came in late. The executor, I was telling them or imploring them, have a conversation with the executor, because she not the mic, it's the box. It's too close to the box. So she now can say, I don't know about this will. I don't know about anybody leaving me as executor. I don't want to be a part of this. I don't choose to do anything. Because yes, you look on her face, she look puzzled like, and she glad somebody here can offer a little clarity because she had think about it. Worse than the person overseas say, I'm the what? Lead executor. The head executor. There's no such head executor. Right? You all have the same rights. So, but that executor, I'll leave that part out. So, no, the executor don't need to be there. Just let me wrap up with the witness. The executors don't need to be there upon the will being drafted or signed. Who needs to be there? The testator and the two witnesses. As I was saying, you don't need a justice of the peace to stamp or sign or seal your will, and you don't need an attorney to stamp or sign or seal your will either. But if the person you're asking to witness is one of the two, they can do so in their capacity as a regular citizen. They don't need to affix their seal or stamp. Right? Recently, I saw a will that was made. The testator signed, the two witnesses signed, and then they had a notary public witness it. It doesn't make the will invalid, because there's the two witnesses and there's the signature of the testator. But if the notary public was signing in the capacity as a witness, it may or may not bring some contention among the beneficiaries, and then we'll have to seek the guidance of the courts. Right? So your witnesses can be anyone over the age of 18. They must not be a beneficiary. Yeah, man, write it down. Because I see it, no, man, I see you taking notes and I see you drawing for your pen and your paper. So, your executor, you are the one that asked about the executor? Oh, you probably the little behind. The executors can benefit, but the witnesses must not be a beneficiary. They must not have any interest in your will. They are needed in case someone decides to contest the will. Then the witness to say, oh, my dad or my mother, whomever the person is, did not leave this will. The court will draw on the witnesses to say, yes, I witnessed the person sign, I witnessed the content, the person signed, and they signed in my presence, and I signed in their presence. Your question now.
Yes. So, this person who has named herself as the head executor, and she mentioned that the situation is dragging out, can she act without the other person?
She can, because she is an executor, and both executor has the same legal authority and obligation. So she can seek guidance from an attorney in acting without the other executor. The attorney will file the relevant documents to the court, explaining to the court what is happening and with the other executor and so on, and the court will decide whether or not they are satisfied in order to issue the grant of probate. So here to the side it said you must sign and date your will in the presence of two witnesses. Next slide. Any person may act as a witness to your will, but it's best you choose what is known as a disinterested witness, meaning the person is not a beneficiary. They have no financial ties to it. You don't want it to be said, oh, you only witness it because you get some. That gives rise to fraud under our law. Someone who isn't a beneficiary and has no financial or personal stake in your choices. Remember, two witnesses are needed. Next slide. Can a will be revoked? Yes, it can be revoked. Can be revoked by 1, subsequent marriage of the testator. 2, making another will. 3, a document made by the testator declaring an intention to revoke. That's the, my friend here, that's the codicil. Right. It's a document that you put in writing. Say you can't find the will. You don't want to make another one for it to supersede the earlier. So you put in writing that you're willing to, this is your instruction to revoke the will it's your intention to revoke the will that was previously made. Or by simply burning or tearing up the will. So those are 4 ways a will can be revoked. So for number 1, if you make your will on the 25th of June and you get married on the 30th of July, your will is revoked. It's no longer valid. Your will date must be after the date of your marriage. You can rewrite it with the same content, but the date must be after the date of your marriage. Next slide. What happens if you die without leaving a will or executing a proper estate plan? Or execute a proper estate planning. Well, proper estate plan. Next slide. So, without a will, you didn't move. Thank you. So, without a will, as I said earlier, you would have died intestate. Same thing as intestacy. So, intestacy, to my friend there that's not so bright, intestacy, where an individual dies without a will, it means he or she has died intestacy, and failing to properly deal with all your assets in a will is known as partial intestacy. Next slide. So, When you die without a will, when you die intestate, the law dictates who gets what. And they are guided, the administrator is guided by Section 4 of the 1988 Intestate Estate and Property Charges Act. It sets out the table of distribution. So here they classify, they have two classes of beneficiaries. They have the primary beneficiary and the secondary beneficiaries. Primary beneficiaries, secondary beneficiaries. So if you die leaving a widow or common law spouse, children, deceased parents, brothers, sisters, grandparents, uncles, aunts, only the primary beneficiaries benefit. But there's a twist to that, so I crave your indulgence. Widow, common law spouse. So a widow is someone who is married, both parties married, go before the pastor and God, and you exchange vows. One person, the husband passed, the wife is now a widow. The wife passed, the husband is now a widower. That's clear. Marriage certificate says that, so a death certificate would prove that the other partner passed. Common law spouse. The law does take into consideration persons living together, and the law calls them common law spouse. But to what end is someone recognized as a common law spouse under the law? So the law states that a common law spouse is a single man and a single woman living together for 5 consecutive years to the date the person dies. Who is a single man and a single woman? Someone that have never been taken before God and man and exchange vows with anyone. They have never been married. That is single. Never been married. However, we are living in a society where persons do meet each other. The caterpillars turn butterflies, and we are all happy. And then a couple of years in, the butterflies die, and it's just dry bones. And there is no Jeremiah, so those dry bones don't come back to life. Yeah, man, I'm from a Pentecostal faith. It's Jeremiah in Ezekiel, so yeah, I have a little knowledge. So there's no Ezekiel, there's no body to pray and bring back the bones to life. So we decide to separate. Upon being separated, you're still married. So if I decide to move out and go back to my parents' house and leave him in the house, we are still married. He's still my husband, I'm still his wife. So we are still not single. But we choose to, I want this baggage off, I want to be free. You have to now submit the relevant documents through your attorney to the court to get what is called a divorce. A divorce comes in 2 phases. First application, once it's granted, you get what is called a decree nisi. After the nisi, the court gives you 6 weeks to see if you can resuscitate the butterflies. If that don't work, after the 6 weeks, you submit further application, and once it's granted, once you satisfy the court grants what is called a decree absolute. Simply mean this marriage has been broken down and it cannot come back. It's irreparable. No band-aid, no surgery, nothing can fix it. So that absolute, you are now considered single. But say during your separation period, you met someone and you move on, because we're not paired with one another, the mind as husband and wife, and we're dealing with divorce. You are not considered single until the decree absolute has been granted. So if you're with that person that you find during the separation for 5 years, your 5 years as common law spouse don't start until after the date of your absolutes.
Okay.
Yeah. So, and the law only recognize one spouse. So if during the separation you leave and you live with someone else and that person gets pregnant and bears you a child and you're living together, that person is just a baby mother. The law does not recognize you. The Lord gives you no recognition over the wife on paper. Because at this time, you are just wife on paper. So the Lord does not give any recognition to the baby mother. In the event the person was never married, but he had 3-4 baby mother, as is the world's character, to have more than one baby mothers. The only one that may stand a chance at obtaining spouseship through the court is the last one, and the court will take into consideration the age of the second child compared to her last child and a whole lot of things. So the stuff that the court will take into consideration is dependent on the situation. So no two situation is alike. Is exactly alike. So there are many things that the court will take into consideration. But once you are or you believe you fit the characteristics of a common law spouse, the court has to be the one to say yes. And so therefore you will have to submit documents to the court. The court will ask for certain documents, ask for certain witnesses, and so on. Once the court is satisfied, they will issue what is known as an order of spouseship. And that document is what you use to declare you as common law spouse. So just getting up and say, but I live with him for 5 years. Yes, you might have lived with him for 5 years. And you are the only person that he has. You can't just, it's not a word of mouth. It's a legal situation. And in law, everything must be in black and white for it to be admitted as legal. No. It must be 5 years. Tell him to hold on. Put him on life support until tomorrow. Them can unplug it. No, honestly, we have had situation at our office where it's just a week or just a month. 4 years and 11 months. The law clearly states 5 years consecutive. So if you leave and come back, the 5 years start running when you come back. No, there was a hand around.
Yes, good afternoon.
Afternoon.
Yes, I know of someone, this gentleman is married, but is separated for many years. His wife migrated overseas, and he's now living with a common law, as you would have stated. I don't think he's divorced. Is there a will that would surpass any claim for the wife, that if he left a will for the common law, and he have children also?
Sure.
But the house that he have is he said it's his house. It's not like both joint tenants.
Sure. If you're separated and you have a will, your will takes precedence when you die. You would not have died intestate. So if you have a will, if you're separated for many years and you're not divorced and you leave a will, this doesn't apply to you. But if there's no will, this applies. The intestate, the table of distribution under the Intestate Estate and Property Charges Act applies to persons without a will, who pass without leaving a will. But you mentioned the will, you mentioned the property. You say it's his house. His name on the title? Was it the matrimonial home? It wasn't the matrimonial home? Okay. Good. If it was the matrimonial home, although his name is on the title, and he left a will, say the wife decide to be mischievous, she can bring a claim under what is called as the Property Rights Act of Spouses, Property Rights of Spouses Act. For short, they call it PROSA, to claim the matrimonial home under that act. So what we do at Administrator General and what an estate planning is just a section or a portion of what we call law of succession. It can go very wide. So while the wife might not be able to claim under the Intestate Estate and Property Charges Act, she may be able to claim under the Property Right of Spouses Act, under the law of succession.
Timeline within which she would have that right to do that?
I am not aware of a specific timeline, but the court will be the one to decide whether you have waited too long or you should have come sooner, or it doesn't matter.
There was a case in the court just this week where the ex-wife, she waited a couple of years after the divorce to file for share of the assets, and the court held that she was not entitled to 50%. She was only entitled to 35% because apparently the ex-husband had developed the whatever asset it was. Yes, just this week.
Right. So
Yeah.
any claim being filed, the person can't just come forth and say, I'm taking this. It has to go through the court. So as I said, she said the court, I am not privy to the case she's talking about. But based on what she just said, the court stated that she waited too long. However, she was still awarded 35%. So the court has the final say given the evidence and everything that is placed before the court. The court has the final say. The court could have said that, oh, you waited too long, so I am not going to award you anything. But the judge, based on the evidence presented, the judge decided that this is the way he's going to go. And I'm sure he did it in his capacity, bearing in mind the acts, the legislation, and so on.
Okay,
So, question?
Well, it's actually related to what Desiree had said. If someone had joint ownership of land, the couple divorced, and one party did nothing. Actually, they don't know what the other party had done in relation to the land. Can a claim be made 20 years later? Okay, joint ownership of land.
Two persons married,
Yes.
held the land jointly.
Mm-hmm.
They separated.
Yes. They
But
divorced.
one party didn't know that it was jointly held.
No, they both know. But one party, after leaving the marriage, just did nothing in relation to the land. Can a claim be made 20 years later?
For joint tenant?
No,
No, but remember, both of them own the land jointly.
mm-hmm.
So it doesn't matter. The land is theirs.
Okay.
Joint meaning, I have 100% share. You have 100% share. That's what joint means. So even if we divorce and separate, once we name on the title as joint tenant, I have 100% share and you have 100% share.
Okay. Sorry. So just a moment. So if one party wants to obtain the 50%, oh no, you said
There's no 50% in joint tenancy. It's 100%. If one party wants the entire property and wants the other person's name off the title, they would have to do what is called a severance. And in doing a severance, you and I own the property jointly. I can say to you, I want to get your name off the title for argument's sake. I want to own this myself. I am willing to buy you out tell me how much you're willing to sell meat for. And we come, once you want, you say, all right, fair enough. Me will take off my name, but you have to compensate me. You will tell me what is it that you're asking, and we can come to an agreement. We can have a negotiation, invitation to treat. You can make an offer. I can accept the offer. I am pay consideration upon accepting the offer. And once I pay you, we do the necessary paperwork to remove my name on it, and we go clear. No animosity, no fighting, no nothing. Outside of that, say I leave for how many years and gone about my business, no business about the land, and I want to get your name off it, I would have to approach the courts. You can't do nothing without the courts in Jamaica. Worse when it come on to land. You have to approach the court and put your case and say, hey, I want this person off. We own the property jointly, yes, but over the years, the person is just that name, their name is just on the title. I have been maintaining the property, paying property taxes. I have developed the property. I've done this, I've done that. Put all your evidence before the court. The court will decide whether or not. So joint tenants is not getting up and say, oh, me I going to take off your name. No. You're welcome. I am running against time. I have 7 minutes based on my watch. Yeah. So let me just briefly go through this and wrap up, and then I'll take the questions in where you guys are not ready to start the other event. So the primary beneficiaries we see here, where you have widow or common law spouse, as the law only recognize one, children, parents of the deceased. But not all will benefit. If you die leaving, if the person die leaving widow, children, and parents, not all three will benefit. The only one will benefit, irrespective of who else is there, are the children. So if it's widow and children, widow and a child, the widow will get 2/3 of the estate, the entire estate. Cash, car, no. Motor vehicle is seen as personal chattel. So personal chattel means it was, once the motor vehicle was used for private use, family trip and those things, it is seen as personal chattel, and it is passed, once all liabilities are cleared, it is passed to the surviving spouse, solely to the surviving spouse. So the house, the cash in bank, the investment, the insurance, once there's no beneficiary named on the insurance, it falls under your estate. So the spouse will be entitled to 2/3 of the value of the estate, and the child 1/3. If there's spouse and children, the spouse gets half, and the other half is shared equally among the children or between the children. The court don't, she says step. Hold your question, but she says step. Children, biological children, meaning name on the birth certificate, or you during the person's lifetime you did what is called a DNA, and the courts and the DNA say you're the father, and the court with that DNA put your name on the birth certificate, then that's fine. Once the name goes on during your lifetime by DNA, then that's fine. If the person dies, if you do the DNA while you're alive and you're the father, but you didn't enter the name on the birth certificate and the father passes, that DNA is not accepted in estate administration. You will now have to go through the courts to obtain what is called a proof of paternity, where the court will ask for relevant documents. The DNA will be accepted under other laws, but not for estate administration. You must obtain what is called a proof of paternity. where the court will establish whether a father-daughter or father-son relationship existed based on the documents that they would have requested. I know one of the documents is an affidavit, where they will ask an affidavit from the father's side. I've heard of them asking for it from other persons as well. I'm not sure of the entire process, but the court will ask for whatever documents needed. Once it's provided and the court is satisfied, then the court will issue a proof of relationship stating that a father-daughter or father-son relationship existed between John Brown and Casey Brown during his lifetime, and this proof of paternity is issued under Section 7 and Section 10 of the Status of Children's Act. And that must be stated on the proof of paternity for it to be admitted into estate administration to prove this child as a legal child of the deceased. Outside of that biological child proven through proof of paternity and birth certificate, the court accepts legal adoption. As in adoption gone through the court and a certificate is issued. The court accepts that. Not you taking a child and say, the child is in my care and protection. That's not legal adoption. Outside of that, no other child or children is accepted as a child of the deceased. So as I was saying, the wife gets 50%, children get 50% shared among themselves. If the person dies leaving widow and parents, then the parent would benefit. If it's children and parents of the deceased, the parent don't benefit. So if you have adult children and you are their dependent, encourage them to leave a will, especially mothers of boys, I would say, because the mothers of boys tend to be entitled or believe they are entitled, but if there's no will, there's no entitlement. Once it falls under intestacy, there's no and there's a child, there's no entitlement for the mother or the father. If there is no primary beneficiary, then it is shared equally among the secondary beneficiaries. If there are no secondary beneficiaries or primary beneficiary, it means the estate is bona vacantia and there is no legal beneficiary, which means your estate falls to the crown. However, if you used to assist this person, you're not related, but say in the church, we do have persons that assist elderly in your outreach program and so on. A young sister or brother might live in and assist with cooking, cleaning, washing, and so on. And you have been doing this for years. You can petition the crown through our office, and we will send your petition to the Governor General, who represents the crown. If it's approved, you will be declared the beneficiary in the estate. If not, the estate falls directly to the crown. Next slide. So in intestacy, the Administrator General's Department only comes in play where the person died leaving a minor beneficiary. So if it's either one beneficiary is under the age of 18 and there's no will, that's where the Administrator General comes in place. Or if all the beneficiaries are adults, but the value of the estate is 1.5 or less, then we can administer the estate. If all the beneficiaries are adults and it's over 1.5, the value of the entire estate is over 1.5, you will have to seek an attorney, and they will assist you in obtaining the grant of probate, and it comes at a cost. Nothing is free. It comes at a cost. So you seek an attorney, seek their services, they will assist you in obtaining the letters of administration. So where there's a will, it's a grant of probate. Where there's no will, it's letters of administration. No will, or the beneficiaries are adult, letters of administration. Where at least one of the beneficiary is a minor, the Administrator General's Department can extract what is known as an instrument of administration. So where you see an instrument of administration, It is extracted solely by the Administrator General for Jamaica, and it means the matter is with that department, and we are the administrator, and there is a minor. The person died leaving a minor. So where the principal from Jesse, they pass, leaving children under 18, the matter is reported, and there's no will, the matter is reported to the Administrator General. We administer the estate based on the Interstate Estate and Property Charges Act, and the asset is distributed according to the table of distribution. The process remains basically the same. We investigate, confirm, clear liabilities, and distribute. So we don't get to distribution until liabilities are cleared. If there was a will, there would be no need. If all their children were over the age of 18, they could get an attorney and obtain letters of administration, and they carry on and to distribute the deceased estate. So we also administer bona fide matters that I spoke to earlier. And another service we offer is funeral expense advance, where the person died, there's no will, they left a bank account, you want to pay the funeral home, you don't have the first dollar, we will assist you in obtaining up to $700,000 from that bank account, paid directly to the funeral home for the burial. We don't cover 9-night and set up and candlelight and all those things. Those are fluff surrounding funerals. What we cover is the package outlined for the burial from the funeral home. However, persons might be smart and want to put a lot of fluff in the package. We do reserve the right to go through and have discussion with you to say, oh, the law does not cover you having 10 buses and stuff like that. We will go through and have a discussion, and we will come to a mutual ground where the law is not being violated, and we are allowed up to $700,000 to release to you. Next slide. I think that's wrapping up. Oh, there are costs associated. I did mention some throughout my presentation. The executive fee, there are legal fees that the attorney will charge. Once there's property, there is transfer tax, there are stamp duties, there are other miscellaneous fees paid at title office as well. Nothing is free, even in death there is tax. Next slide. Next slide. Just continue until I tell you to stop. I did explain what are grants. Go back a little. Those are the 3 grants. Grant of probate, issued where there's a will. Grant of letters of administration, issued where there is no will and the beneficiaries are adults. And the grant of instrument of administration, issued where there is no will and there is a minor beneficiaries, and it's issued only to the Administrator General's Department. Next slide. So there are some things to consider. Have a basic estate plan in place. Take an inventory of your assets. Discuss estate plan. It doesn't mean when you discuss it, you're going to die. Do a will as one of your estate plan, or explore other estate plan. If you do a will, sign the end of your will in the presence of your 2 witnesses, and you're free to amend your will at any time. This takes me to the end of my presentation. We could have gone the entire day, but it takes me to the end of my presentation. You have been a good audience. I really appreciate your interaction, and I will now take questions. Question there.
You spoke a while ago about taxes, the death tax. I want you to explain to us how it is accumulated. There's a question that I'm asking because sometimes when people do their will, right, they have it there put down for years, and when problems occur, and you inquire about the will, you realize that the will was not probated, and if I'm not mistaken, the time that you take upon death to probate the will, the death tax is incurring. So I want you to explain to how it is how it accumulates in relation to delay. You get what I'm saying?
I can't explain in its entirety to the to the figure, but from where I sit, I have some knowledge of. So I'll speak based on the knowledge that I have. So in law, once you have a property, you are charged the person passed. Once you're living, you pay property taxes. You might see me pause every now and again. I have not been well for the past 2-3 weeks, and I am experiencing some dizziness every now and again. So, and because I've been standing here for so long, it might. I just had some water. I really don't like sitting. I'll just try and bear it until. But because this was scheduled from January, I could not forego. So you have to pay what is called estate duties, also known as. No, let me use estate duties. Estate duties. It's a tax payable upon death. So the minute you drop dead, the tax start run without you or your beneficiary knowing. So it is as at date of death. So the person died June 25, 1976, and the person leave a will or no will, estate duties must be paid. So they use the date of death. They use the value, however, that's a good thing. They use the value of the property as at date of death. So if, as at 1976, the property valued $5 million, you would have paid, I don't know the percentage, but they would calculate it on the $5 million. The law, however, was amended a couple years ago where they moved the threshold. So properties valued $10 million and below as at date of death is exempted from estate duties. Over 10 million, it is the amount over the 10 million that the estate duties is calculated on. So, person died in 1999, left a property valued $15 million at night. So you know I must some big house them time there. 15 million. We are now administering in 2026. Estate duties is charged on the 5 million as at data date. So say the amount as at June 1999, say it was 46,000 as at that time. Interest is then calculated from June 26, 1999 up to today, the 21st of March 2026, and after if it's not paid today. I know the interest, I believe, is 0.5%, but I don't know what is the percentage charge on the actual value. And that's a daily. So the 46,000, if you had known then, in 99, can easily well become 100 and something thousand now or more in 2006. So that's the estate duty, one of the many tax or many fees. Let me use fees that he spoke about just now. Payable is payable to the government through tax administration, the stamp commissioner's office. So where you will go to get your document stamped, that's where it's paid.
I know you
Last
might
question?
not have.
Hold on, that's the last question? That's what you're saying? Oh, okay.
I know you might not have knowledge of this, but outside of making a will, is there not have the answer for this question, but I'm going to ask it. Outside of making a will, is there any other legal way for persons to leave their assets and anything else? Oh, I wasn't here at the time.
I did go through that. There's also nowadays person asks about setting up a trust. I did some investigation. I mean, as I told you guys, I'm on my law journey, and I think it's one of the areas that I would want to go in. Because setting up a trust, it would relieve the beneficiaries of some of the fees that would have accrued as at day-to-day. And also, persons are now exploring deed of gift, where the property is passed as a gift to someone, but that's done during the person's lifetime. So they set it up, pass it as a gift, and I don't know everything around the deed of gift, how it is done, how it is executed, but I know of it, and I'm sure as I go further in my law journey, I will learn and can probably come back to inform you guys about it. It eliminates a lot of fees associated, and also minimize the obligations of the executors and even the beneficiaries. So, or the person obtaining whatever gift is left. So those are other ways also of estate planning.
Available to persons who would want to?
There are attorneys that I heard that there are at least 2 attorney firms. I don't know which 2 that does trust. At least 2. It's not prevalent in Jamaica, but the deed of gift, you can get the services of an attorney. The attorney fee, I don't know. You and the attorney will negotiate that. But it is more cost effective. I did a presentation the other day where after the presentation, the person came to me. She was asking a lot of questions, but she came and she said, I'm a beneficiary under a will. But the person died, and I think she said she was an executor, but she said there's not much to administer because he left me all the land, the properties that he owned, and it's quite a hefty amount of property. But what he did, he said it would have cost me too much real estate duties and other fees. So he did an inter-virus transfer to relieve her of having to pay all those fees at the end. Because most of those fees, as I mentioned, is payable in death after the person dies. So once you're alive, yes, you pay transfer tax, but I think transfer tax is 1% and so on. There might be other fees to execute the transfer on the title and so on, but those are standard fees. But the estate duty, it can be a lot. It can be. For the beneficiaries.
Just one final question. Is those estate fees, can they be waived at any at all? Do you know of any procedure that can they be waived?
Estate duties, the Tax Administration Jamaica has the right to, or has the power, not right, has the authority to waive estate duties where the home was the matrimonial home. They have the authority to do so. However, it's not a must. They can decline the request for it to be waived. But in my case, at my office, I have sent over requests for waivers where the home was a matrimonial home. What we'll do is send certain documents. We'll send the marriage certificates. We'll send, along with the standard documents, we'll send the marriage certificate, and we'll have what is called a statutory declaration be executed by the surviving spouse to say that it was the principal place of residence during their marriage. And I have never gotten a request being denied after making my application. So I do know they do that, waiving the estate duties on matrimonial homes. Any further questions?
Yes, I have one more question. Giant tenant. I know of this situation which this person acquire a house, but he just used a relative point to acquire the house. So all mortgage and everything have been paid by that person. And the other party, the man have a child, but the other party doesn't know and he doesn't want the property. So could that be done as a gift of deeds in that sense?
Both persons' name is on the title? Both persons' name are on the title?
Yes.
It's a joint tenant.
Yes, a joint
Remember,
tenant.
joint tenant, both persons own the property 100%.
Yes.
So you're not transferring, you can't transfer as a deed of gift. What has to be done is a severance of the joint tenancy. So they will, as I said earlier, get an attorney or find out how they can go about severing the joint tenants. Where if the person is willing, there are relevant documents that the person would have to sign, both persons sign to agree to sever the joint tenancy. And that will be done once they complete all signing all the documents and the joint tenancy has been severed. It will be entered on the duplicate certificate of title and that transfer be done at that time, naming just one person the owner of that property.
What I mean, they checked that out and the cost was hefty. That's why I said.
Oh no, it's a severance has to be done. You can't transfer a joint tenant.
No, I know what you're saying.
So a severance has to be
I
done.
know what. So
There's no going around it.
Yeah. So if the person for the house died, I'm saying if the other party that are alive could sign it over to the man child as a gift of deed.
Okay, so if the person, but it's still going to cost you.
Okay.
Everything in law going to cost you to get done. But if the person can agree to, they don't must do it, but they can agree if when the person dies, the property, the right of survivorship will give that person now, the surviving person, the owner, sole owner. The person can now choose to transfer the property to the other person's beneficiaries. It is still going to cost. Don't know which one is cheaper. I can't speak to it, but it is still going to cost.
Thank you.
You're welcome. Last question here.
Yes, I'd like to know. Okay, so I die, but I know that I'm going to die, and I don't trust those around me. I want to make sure that the will that I have, nobody can manipulate it. So, what is the best course of action? My will is going to be there for somebody to find, but I want to make sure that the right person gets it. Yes.
So, you say you don't trust anybody, so that means your will wouldn't have an executor. Remember, for a will to be valid,
it must have an executor.
No. For the
It must
will
have
to be
two
valid,
witnesses.
it must have the
Two witness-
testator's name and signature and date and 2 witnesses.
Right.
So your will though must have an executor.
Okay.
But we encourage you to name an executor for smooth smooth
processing.
processing of of your will after you pass.
Right.
But you say you don't trust anybody, so I'm assuming there's no executor. So
Right.
if there's no executor, one of the beneficiary under the will can offer themselves to be the executor, the legal
Okay.
representative.
Okay.
The lawyer, the attorney will file the relevant document. The court will appoint. The court says satisfied, they will appoint that person as legal representative or the
Okay.
administrator of the estate.
Okay.
Outside of that, you have the option of naming the administrator general and executor under your will.
Okay.
But you do have the option of naming the administrator general executor under your will, right?
Okay.
When you make your will, you can store your will among your important documents. You
Right.
can give it to a friend, but in your case, you don't trust nobody, so you're keeping it.
No, it's not that I don't trust my family.
Your
It's my
family.
family I don't trust.
But you might trust your pastor,
Okay.
your pastor wife, your church sister, your deacon, your deaconess, whomever. You have somebody you trust. You can
But
give it
I'm
to
so
them.
confidential that those who I trust, I don't want them to know the details.
Okay, so what you can do is register a copy of that will
Yes.
at the Registrar General's Department, or let me say it correctly, at the Office of the Registrar, formerly Registrar General's Department.
Right.
You can register a copy with them.
Okay.
That's the only copy the court will accept if they can't find the original.
Okay.
But I have told persons, write your will in triplicates, more than one. Sign the 3 of them. So you have 3 original.
Okay.
So you have one, your attorney might have one, your pastor might have one, and you record a copy at RGD. In the event that we can't find any of the 3, persons can do a search at RGD and the court will accept that copy.
Okay. Thank you very much.
So I believe that takes me to the end of my presentation and my interaction with you. Thank you guys for having me. I'm Latoya Williams. I'm a trust officer at the Administrator General's Department. We can be reached. Our telephone numbers are at the back of the brochure. Our website is there. You can visit our website, get further information. You want further clarity, you can always contact our office and one of our customer service rep or our trust officer will assist you as best as possible.
Miss Williams.
It's okay, let me borrow hers. Okay, so I'm going to ask 3. We go out, we take a little token with us. It's not much, it's not, anything big. But to remember me and remember the Administrator General, before I get there, if you know of anybody, how can a matter be reported to us? Anybody can report a matter. If you know of someone who passed, don't know how they're going to manage, but the person that passed, they used to work, they might be entitled to NHT, they might be entitled to unpaid salary. Encourage the surviving spouse to come and report the matter. Once there's a minor, come and report the matter. If they're not sure how much the estate value, come and report the matter to the Administrator General's Department. We'll investigate and we will collect the assets, distribute. We will assist in the maintenance of the child up until the child reaches 18, and then we pay over the balance of their entitlement that we have there to them as the beneficiary. So I have 3 water bottles here. I am going to ask 3 questions. I'm sure you all will. She get up. Me know she would have win one because she have all our notes. So I'll just ask 3 questions, and you have the opportunity to win a water bottle, or to receive, not win, because it's not a competition, to receive a water bottle from me. Name at least 2 of the documents that is needed that the court needs to issue for someone to administer an estate. At least 2 of the documents. Remember, name. You go on. She gonna try. Mhm. All right. I have a water bottle for you. Okay, she gave you two. Letters of administration, instruments of administration. What's someone tell me the difference? Than that. Letters of administration, instruments of administration. What's the difference? No. No. Letter of administration where there's no will, yes, you left off a very important piece. Yeah, you left off a important piece. There's no will and that. And then instruments of administration, you're totally wrong. So go again. Anybody else want to try? Letters of administration, instruments of administration. What's the difference? Letters of administration, instruments of administration. What's the difference between the two? You can't flap me, no, because me in here a vouch for you, so you take notes and you come tell me no. She wants to try. She said she'll win it and distribute it accordingly and give it to someone. Try. No, nobody gonna further. Right. And wait, there's no will and no. But let me hear what you were going to say about the instruments. No. So I stand up here, so I talk and almost drop down for nothing. No. Instruments of administration. And it is only extracted by the administrator. So the letters of administration, no will, all the beneficiaries are adults. The instruments of administration extracted only by the Administrator General's Department because there's a minor involved. So, 1, 2, I have one more question. Give me one purpose. Give me the mandate of the Administrator General's Department. What do we do? Why are we here? What is the purpose? No. He's reading our mission statement here. So our mission statement, our vision statement is to protect the interests of minors, beneficiaries, and creditors according to law. But I am going to give him, he went in deep searching to find, but we administer matters where there is no will and there is at least one minor beneficiaries. So I have 3 water bottles and I don't know if somebody want the bag, I can. You're getting a water bottle, so you don't want the bottle, you want the bag? Oh, so you want the bag. Oh, so we have a next water bottle up for grabs. No, I just don't want. You know, it's true. I'm not going to ask no further question. She was the most interactive person. She come in for a water bottle, but wait.
On behalf of the Faith Temple Pentecostal Assemblies, yeah, man. Yes. On behalf of the Faith Temple Pentecostal Assemblies and the auxiliary department, we offer you this token of appreciation. It is heavy, so I don't want to lift it up and right. For so efficiently, yes, and resourceful in giving us the information, the knowledge of administering of estate, and for bringing, okay, and for enlightening us. There are many things that I knew, but there are many things that I am just acquiring because of what you present. So we really appreciate you taking the time to come to us and to so efficiently give us the information that will aid us in planning our estate. We wish you all the best, and we pray that the Lord will bless you and for your further development, that you will be successful, and even you will get some clients from here while you do the trust, because I'm interested. God bless you.